All right. Let me just start off by saying if you have your cell phones, please make sure you silence them so we don't get any calls during this salon. I want to just say a few things about the salons before we begin for those who aren't familiar with them. I'm Ron Collins, and welcome. This is our 9th First Amendment Salon. As some of you know, the salons began in April of 2014. The salon hosts a series of nonpartisan programs designed to foster an open dialogue about various free speech issues. At each salon, 25 or so people gather at different venues that are electronically connected by video conferencing, and the salons typically take place in New York or Washington, D.C., at the offices of the law firm of Levine, Sullivan, Koch, and Schultz. In September of 2014, as some of you may know, we went on the road and went to Los Angeles. Earlier this year, last year, we went on the road to Los Angeles and had our first on-the-road salon there at the Davis Wright Tremaine law firm there. In September of 2014, the salons formed an association with the Floyd Abrams Institute for Freedom of Expression at Yale Law School, and we're delighted to have them as a partner. I co-chair of the salons with Lee Levine and David Scover. And tonight we are especially pleased to have two distinguished participants engage in a dialogue for us. Both participants this evening clerked for Justice William Brennan, one in the 1972-73 term and one in the 1962 and 63 term. Both have long affiliations with the University of Chicago and both still teach here. You know their names. Jeff Stone here, as you know, is the Edward Levy Distinguished Service Professor here at the law school. He is the author of the much acclaimed Perilous Times, Free Speech in Wartime, and the author, and you heard it here first, of the forthcoming Dissenting the Constitution, which will be published next year by Norton. And we are also pleased to have with us tonight Judge Richard Posner, who you know sits on the United States Court of Appeals for the 7th Circuit, and as last I counted, he's authored some 40-plus books. I think it's plus. And his most recent work is Divergent Paths, the Academy and the Judiciary, which was published earlier this year by Harvard University Press. I am delighted, and I know you are, that to have Jeff, and the judge has given me the liberty to refer to him as Dick, so I will, or Richard. I'm delighted to have both of them here, and we much appreciate the time the two of you took from your schedules to make this program possible tonight. So with that, I want to thank one final thing, Jeffrey Stone, who also serves on our advisory board, and he made this event possible. So Jeff, a big thank you. And with that, what will happen is Jeff and Richard will speak for about a dialogue for about 50 minutes or so, and then we'll open it to you for questions and comments. And with that, let us begin. Welcome, Washington, D.C. Welcome, New York. And it's yours.
So Dick, to start off with, what in your sense was the purpose of the First Amendment's guarantee of freedom of speech and press?
The purpose?
Yeah, what was it designed to do?
Well, I think the people who wrote the Constitution were, they were trying to get away from the English. Well, let me start over. The Constitution is largely copied from the English legal system, but they did want to get away from certain features of English government, and they worried about censorship and an all-powerful government that would stifle debate and disagreement. So, of course, they didn't really explain anything. They just say free speech. It doesn't tell you. And no one actually believes in unlimited free speech. You wouldn't have any copyright law if you really took free speech literally. But, there's a professor here at U of C, David Strauss, who thinks that what we call constitutional law is not in the Constitution, that the Supreme Court simply treats the Constitution as a authorization of the Supreme Court to create a common law of constitutionality. I think that's realistic. What we have today in the way of constitutional concepts really has no serious connection with the 18th century.
So, in light of that, what lesson would you draw from the fact that less than a decade after the framers adopted the First Amendment, they also adopted the Sedition Act of 1798? What does that tell us, if anything, about what they thought the First Amendment did or didn't do?
Well, I think they probably thought that that freedom of speech was a value, but there are a lot of countervailing values, such as national security. So we have serious concerns about the safety of the country. Free speech goes down the drain, which I think makes perfectly good sense.
I mean, part of the question then, of course, is how do you decide whether the threat to the nation's security is great enough to justify restrictions on free speech or press? So even if one agrees that it's appropriate to take that into account in deciding whether any particular speech or press is protected, from the Sedition Act context, it didn't seem that the supporters of that legislation were all that afraid for the national security. They used that as an excuse, right? But it seemed that they were really much more interested in electoral politics at the time. Does that matter? I mean, are they being cynical and that make us think this whole thing is about nothing?
I think it's fine to have the Supreme Court taking on itself responsibility for creating a body of free speech law, and then the court and lower courts have to decide whether the government has made a good case for limiting speech. If you look at the sorts of things that are limited, defamation, I mentioned, copyright law, threats, right? So, for example, one very effective form of communication is assassination, but that is generally forbidden, right? Even though it's very expressive. So, so I don't think you can really generalize, except to say some body, like the judges, are going to decide whether some measure of restriction of speech is justified. You know, it's sort of costs and benefits. There are costs and benefits to freedom of speech in particular circumstances, and that's really all there is to it.
So why don't we take a look at a couple of landmark First Amendment cases and get your sense of how you would have approached them. Okay, so say Dennis versus the United States, right, where the court upheld the convictions of leaders of the Communist Party. Did the court do the right thing there?
Oh, I think so. I mean, he had learned hand writing the opinion in the Court of Appeals upholding.
Right, but he was following the precedent at that point. Right,
but I think it represented his views, and there was a lot of concern about communist subversion in the United States in those days. I don't see any real problem with that. Do you?
Yeah, do I? I do. I mean, I think that I think Dennis was wrong in the same way that had the Supreme Court upheld the Sedition Act of 1798, it would have been wrong. That is, that there was a case made, a claim made, that the reason for the government's action was national security, but that the court should look at those claims with a degree of skepticism, given the fact that there's also a motivation to suppress speech you don't like, just because you don't like it. And that's not really national security. And so I would say in both of those instances, for example, it would be appropriate for the court to invalidate the law, not because there aren't circumstances where the threat to national security might conceivably be sufficiently great to justify restrictions on speech, with a real clear and present danger type test, for example, but that in both of those cases, I think the court was allowing. There was no first case. There was no Sedition Act case, Alien Sedition Act case. But in both of those situations, I think upholding the law would have reflected an inadequate degree of skepticism on the part of the justice.
Well, I don't know enough about the Alien Sedition Act, but as far as Dennis is, look, the Communist Party, USA, was an arm of the Soviet Union. It had no autonomy. During World War II and afterwards, the communists penetrated deeply into American government. You know, the OSS, our predecessor to the CIA in World War II, it was honeycombed with Soviet agents. Actually, when I did some writing on some years ago, and happened in a book to chance upon the name of a man who was a close friend of my family, my parents. My parents, very left-wing. I think my mother may have been a member of the Communist Party. I don't know. Really stupid ideas they had. And, when Stalin died, I was a kid. Stalin, that was a tragedy in our house, death of Stalin. My parents did not believe anything in the New York Times. They didn't believe there was, concentration camps in the Soviet Union. They didn't believe it. No sense. So anyway, I find the name of this friend of the family, who I really liked, he was very smart. He had been in the OSS, and the Venona tapes that FBI spying on communications between United States and Moscow discovered that this, I won't mention his name, although he must be dead by now. They discovered he was a Soviet agent in the OSS with a lot of other Soviet agents. And but they didn't prosecute. They fired him. Then he sued them for firing him. They didn't prosecute him because the evidence they had that he was a Soviet agent, although airtight, it was what's called the Venona tapes. So the FBI had been, tapping communications between Moscow and the Soviet embassy in Washington, and they absolutely refused to release the Venona tapes to the president or the Justice Department. So any doubts about Alger Hiss having been a Soviet agent were dispelled when the Venona tapes finally, many years later, revealed that he was indeed a Soviet agent. So my family friend was not prosecuted because they wouldn't reveal, their only source was the Venona tape. So he turned around and sued them for firing him because they couldn't give a reason. But he lost. But he went on and did fine. He was very, very smart, fun person. But as I say, the Communist Party was foreign. It was a foreign. It was a tool of a hostile foreign country. I don't know why you'd protect the free speech of foreign agents.
So you would draw a distinction then between Dennis and, say, the World War I cases, where the government prosecuted individuals who criticized the war and the draft in ways that the government claimed interfered in significant ways with the war effort, but they were not agents of a foreign power. So
Right.
would that be the key difference in your mind?
What is the phrase? Intra belles leges silentium or something. That's garbled Latin. But the notion is that in wartime, laws are silent, which I think is perfectly sensible. We've done things, well.
So you think the court had it right then in cases like Schenck and Frohlich?
Yeah, I think so. I mean, I don't think it probably wasn't necessary. These people who, picketed the draft officers, they weren't doing harm, so probably it wasn't necessary. But, one thing, this is very important, like a very much criticized act of U.S. government in the Second World War was the relocation of Japanese Americans on the West Coast to inland when the war started, for ostensible fear that these Japanese Americans would become a fifth column helping the Japanese. Because, of course, at the beginning of the war, right after Pearl Harbor, Japan was riding high. So this was criticized. Later, the government provide compensation for the Japanese Americans because, in fact, they were entirely harmless. But what Roosevelt did was right in ordering them relocated. And the reason is that when a war starts and you are the country attacked, the most important thing for you to show is you show your citizens that the government will stop at nothing to win the war. That's essential to civilian morale. And Churchill knew the same thing. So after when the Germans, when the English were driven out of France, with the fall of France and Dunkirk and so on, and the Germans started bombing London and Coventry and all sorts of other cities. And Churchill did something that made no strict military sense, which is that he had British bombers bomb German cities, bomb Berlin. Did no damage, it's pointless. But it wasn't pointless, because it was telling the British that Britain would stop at nothing, kill German civilians by the tens of thousands if they could. And as I say, I think showing your people that you're going to place no limits on what you're going to do to win is very important for morale.
Sounds like Make America Great Again. So no, with that in mind, what about ISIS? So two issues, right? One is, would you allow the government today to suppress any pro-ISIS messages that enter the United States or within the United States? And taking the Japanese internment example, would you think it appropriate to intern all Muslim Americans?
Because the vast majority of Muslims are not involved in terrorist activities.
Wasn't that true of Japanese Americans as well?
Pardon?
Wasn't that true of Japanese Americans as well?
Yes, but the difference is, the Pearl Harbor attack was extremely disturbing to people. It was a total surprise. It did tremendous damage to the American military establishment, which was very limited at the time. But
9/11 was even worse.
What is true about if there are more, San Bernardinos, there will come a point at which the country will be ready to deport its entire Muslim population. But the attacks the attacks so far, there've been attempts. I had a case a couple of years ago about a terrorist threat in Chicago, a serious threat, although foiled by the government. But if this became more frequent, if there were more, so you have the Boston Marathon killings, you had a few incidents in New York, and you have San Bernardino. In a country of 315 million, those incidents are sufficiently small that you're not going to go berserk, drive out the whole Muslim population, even when 99% of them are loyal. So, but I say, if this continues, it gets worse, there will come a point at which the country will react ferociously.
The question, I guess, though, is not whether the country will want to react ferociously, but whether the court should prevent it from doing so. And there is, in theory, a difference between the desire to behave that way and what the Constitution permits.
Well, you know, traditionally, the courts did not interfere with war measures by government. I mean, a good example of this is when Chief Justice, the beginning of the Civil War, Chief Justice Taney granted habeas corpus for some Southern sympathizer in Maryland. And so ordered the guy released, and Lincoln simply ordered that he not be released, which was absolutely the correct thing to do. Couldn't let Taney, of all people, run the government, interfere with the government in the Civil War. Beginning of the Civil War, it's like the beginning of World War II. It's the most dangerous time, and you have to show complete firmness. And forget about, there's a lot of really silly old stuff in law. And I really like the idea of the executive defying the courts, not every day, but there are times. So we had this incident in Illinois. So Illinois, Chicago is broke, Cook County is broke, state of Illinois is broke. And in part, this is because of gigantically luxurious pension conditions for retired civil servants, as I mean, grotesque pensions. And these were, the mayor tried to cancel the or reduce the pensions, and the pensioners sued, and the Supreme Court of Illinois, citing a provision of the Constitution about, I don't know, sacredness of pension contracts or something, invalidated the attempt of the city to curtail these pensions, thus digging Chicago into a deeper financial hole. And that was, I thought, really stupid. What they should have said is this provision, this constitutional provision about the sacredness of pensions, this was adopted in a different era. They didn't foresee what has happened to the finances of the city. So we're not going to force that old thing. That would have been the sensible thing to do. And there are I think there are a number of occasions where that's the thing to say. I mean, suppose, for example, that a president was elected who, instead of being 35, was 34. You think the Supreme Court should say, oh, well, sorry, you're out. Supreme Court says, the Constitution says you have to be 35. No, that would be ridiculous. The country wants a 34-year-old. Let him, right? It's called democracy.
Didn't you hold state laws prohibiting same-sex marriage unconstitutional?
Pardon?
Didn't you hold state laws prohibiting same-sex marriage unconstitutional? What about democracy?
Yeah. Pardon?
What about democracy?
Well, democracy doesn't override everything, right? Would it? Why would you want to?
Well, I was
take that
trying to see what the line was. As to
there is no line.
It's just whatever cost.
You take it every. You take.
Right.
There's no line.
Okay, let's take a look at another Supreme Court decision that was kind of a landmark one. How about Roth versus United States? That is, the question is obscenity
The
appropriately,
obscenity
is obscenity appropriately unprotected by the First Amendment? Does that make sense?
Well, it once made sense when people were really very upset by pornography. Now and beginning of, not quite in the 50s, a little later. Now it's just everybody accepts it.
But in 1957, that wasn't the case. So when the court decided it, would you have agreed with the premise that there is this category of sexually oriented expression that is not protected by the First Amendment?
Well, of course, we do continue to forbid, child pornography and so on. Hard to think back to the 50s. I don't think it made much of a difference whether they invalidated or not in the 50s. Actually, the case I particularly dislike from that era, so I've forgotten which it is, I forgot its name, was the one that forbade school prayer, public school prayer.
Engel versus Vitelli.
I think it's really stupid. The reason it's stupid is that school prayer means nothing. There's some kids come from religious families. Oh, I think it's great. The rest of the kids, they don't care. It doesn't register. When I went to school in the 50s, there were Christmas. Christmas was a big thing at the school, public school in Westchester. So, and there was a Christmas pageant for the whole school based on Book of Matthew and the Christ child and the wise men, and the star and all this stuff. And I was always selected to read the relevant passages of Matthew. Now, I have no religious feelings at all. I'm actually quite hostile to all religions. But it never bothered me.
Having been raised by communists.
It was just. Well, actually, it's true, because what it meant was, I was thinking about this the other day. For some reason, I'm pretty sure now that in my household growing up, the word God was never mentioned. And so my parents were nominally Jewish. So once in my entire childhood, they took me to a Seder, Passover thing. And I was so bored that I took the matzah in front of me and I ran it through the candles. I had little candles on the table, and it blackened, and I ate it. It was sickening.
I thought you were going to say you wrote a book on it.
So no, but as I say, the fact that there were these Christmas things, and and the Pledge of Allegiance changed to inserting under God. Of course, I would never say under God, but there it is. But I don't think having public school prayer, these observances, they please the parents of the kids who are religious, but I don't see that the other kids are bothered. Maybe there's some kids who are bothered. Most just slough it off. It's just something that goes on in school, made by adults, and you don't have to buy into it.
So what do you think about Citizens United?
Oh, I think that's terrible.
Why? What about democracy?
What about democracy? What do you mean by democracy?
No, democracy cuts your way here. So.
No, the problem is you have a form of bribery, in which you're a billionaire, so you give money to a politician. Politician very grateful. Politician knows that if he doesn't, at least most of the time, part of the time, what have you, vote for measures that you, the donor, support, you're not going to get his donations next time. And that's a disaster. When, for Republicans in Congress, when a new member of the House of Representatives is elected, he gets a card from the Republican leader which says, you shall devote 5 hours a day to fundraising. And now that's 5 hours during your working day. Now, dinner, after dinner, cocktails and stuff, you'll also be sucking up to donors. Now, with that kind of obsession with fundraising, of course it has to be a quid pro quo. I mean, this Supreme Court, it's really a mediocre institution, if ever there was one, and it's sort of nadir now. Supreme Court thinks, there's a terrible opinion by Roberts, which they say, the reason that the billionaires give the money to a particular congressman, and the congressman takes it, and that the congressman then votes for measures that the billionaire likes, is that they just think alike. They just happen to have the same, there's this happy coalescence of their political views. So it's not bribery, because the representative doesn't change his mind about anything. Of course, the representatives, the congressmen generally, they don't have principles or anything. They just care about being reelected for as long as they want to be congressmen. And then also very important to them, as part of this bribery system, they want to get a good job after after Congress. Good job is being a lobbyist in Washington. So again, you're going to be a lobbyist. You're going to be working for these rich people, and they will want you to have shown your loyalty to them when you were a congressman. So I don't know where Citizens United is just the product of conservatives. Doesn't have anything to do with democracy, law, right? That's what you think.
Yes, it is what I think.
Right.
So on that note, to what extent did the justices actually try sincerely and effectively to apply something called law, and to what extent are they simply acting out of their own ideological, political values and imposing them on the nation on the pretense that it's constitutional law?
Well, I look at it differently. I wouldn't say pretense, because pretense suggests consciousness that you're doing something you're not supposed to do. And there's a line in Shakespeare somewhere: no man is a villain in his own eyes. So whatever you do, you're likely to coat it with a layer of disguise. But the most important thing is not the conscious disguise views. Most people, in making decisions which are not, mechanical, they're not adding 2 and 2, but deciding how to vote in a case, they're likely to be guided mainly by what psychologists would call their priors. And those of you familiar with Bayesian theory. So what Bayesians say is, if you're given a problem, if you're given a question, when you first encounter the question, you will be bringing to it whatever feelings, emotions, knowledge, whatever you have. It's just automatic. You see a problem, a whole bunch of reactions well up within you. Now, after that first encounter with a question, you may try to find evidence. And the evidence may shift you from what your priors had told you would be the best answer to the question. But the priors usually persist and exert significant force, especially when the evidence is uncertain. You know, it's not like math or science. Some evidence, this decision would have certain consequences, but you're not sure, and so on. So I think the result of this is that judges very strongly influenced by career, personality, religion, if they're religious, and as far as, and I think these factors, I mean, look at the Supreme Court. I have a lot of cases that do not have an emotional or political dimension, but a great many of them do, and then they're being pushed by their feelings. I don't think they're being analytical.
So I interviewed Edward Snowden last week, and he said that in response to my question, he said he would come back to the United States and face trial if he was allowed to present a defense of justification. Do you think the First Amendment should protect what Snowden did?
What, stealing government secrets?
Publishing, right? Making public. Why?
Because it's important to the government to be able to keep documents and so on that important to national security. And
suppose he had revealed programs that were unconstitutional.
How would you know they were unconstitutional?
Well, who's the you? So.
Well, if they're if they really bear on national security, then their concealment should not be unconstitutional, right?
Well, but they may be unconstitutional.
Pardon?
The programs themselves may be unconstitutional, even though the government's doing them in secret. Indeed, one of the reasons they're doing them in secret may be because they're unconstitutional. And so the point is, once they're exposed, right, a court hypothetically might say those were unconstitutional programs. You can't do that. So, but it never would have gotten to the court if someone hadn't leaked it.
Yeah, well, no, that would be okay, sure.
So the First Amendment protects it.
Yeah, I would think exposing an unconstitutional program would be in the public interest. You wouldn't want to. Yeah, I don't have a problem with that.
And so, what if the leaker reasonably believed it was unconstitutional?
Pardon?
What if the leaker reasonably believed it was unconstitutional?
But it wasn't.
But court ultimately decided it wasn't.
Then I think he can be punished.
So strict liability.
Well,
if you're wrong, you're done.
It's dangerous, of course, to have people reasonably but mistakenly believing that there's an unconstitutional program and leaking it all over the place. So I think you want to hold people to a higher standard. I mean, if you believe that there are important national security secrets, which I do, but maybe not. Maybe that's wrong.
So what about the press? Suppose Snowden gives these documents to the media, and the media then publishes them, and they're not unconstitutional. The programs they reveal are not unconstitutional, but after people learned about them, they may revise the programs somewhat through the democratic process. But we would never have known about them, A, but for the leak, and B, but for the public. I assume you'd say you would punish the leaker.
Yeah.
What about the press then? Should they be treated any differently?
No, I don't know why you treat it differently. If the press is complicit in a breach of government security, I wouldn't privilege that.
So then you don't agree with the Pentagon Papers case?
Um,
Where the assumption was Ellsberg could have been convicted.
We just went blank on us.
We've got you. Can you hear it?
Okay. We're looking at a Life's Good screen. Oh,
Oh,
there you
yeah.
are.
Okay. So
I'll check on that.
Okay.
We've got you.
Right?
Go ahead.
Okay. So in the Pentagon Papers case, Ellsberg stole the documents like Snowden. Ellsberg did not reveal anything that was unconstitutional, and the New York Times and the Washington Post published them. And the question is, are they protected by the First Amendment in that situation, even though Ellsberg wouldn't have been?
Well, it's a more complicated case because the Pentagon Papers, the revelation of the Pentagon Papers did not have any significance for national security. I mean, they're sort of interesting. They didn't give away any actual secrets.
Well, one of the things the government argued, and I think was credible, is that it disclosed the fact that a number of other nations had made secret deals with us to enable us to use their air bases and so on, and that once that information was public, other nations would be much more reluctant to enter into those kinds of arrangements with us because they now know we can't keep secrets.
Yeah, I didn't know that. I mean, but that's my recollection. I don't remember that from the Pentagon. But that would surely be a small part of the Pentagon Papers. Most of it, as I recall, it's about the planning for the Vietnam catastrophe and so on. It was actually revealing of how stupid our government was, and I thought that was the sort of thing people ought to know about. Absolutely. So you want the public to be able to monitor government activities, but you don't want them to be able to get the formula for, the hydrogen bomb.
So you would have protected Ellsberg as well?
Pardon?
So you would have protected Ellsberg as well? Because the press would never have gotten
it. If there's some little piece, as you suggested, that was, improper to release, dangerous to release, then you might punish him for that, but not the entire Pentagon Papers.
What's your assessment of the Roberts Court's general jurisprudence when it comes to free speech?
Terrible. Free speech. Free speech. I'm not that familiar. What have they done?
Well, one argument, obviously campaign finance is one, which you've already talked about. Another obvious area is, what was I going to say?
Well, there's the McCutcheon case,
right,
Boston.
The abortion.
Oh, that was so stupid. That is such a stupid opinion. I hate his opinions. Yeah, that's where he says ridiculous stuff, that the sidewalks of America is where people meet and exchange ideas, and what he's talking about is the abortion clinic wants to have a 30-foot, zone where the crazy people with their pictures of the slashed fetuses can't come in and terrorize the women going to the abortion clinic, which is not a pleasant situation to be in anyway. So the notion that these people, now what was true is that McCutcheon, or whatever her name is, she's pardon?
McCullough.
Right.
McCullough?
McCullough.
McCullough. She's a very grandmotherly type. She's sweet and so on. So she's not holding up pictures of slashed fetuses. Of course, within 24 hours of the Supreme Court's decision, all the shrieking fetus protectors were back in the 30 feet. It was ridiculous. But what particularly bothered me about his opinion was, and he says a lot of things which are completely phony, is the proposition that the sidewalks of America are the places where people exchange ideas and, get educated about politics. What happens if someone accosts you on the street with a political proposition? Because you run. So Roberts is guilty of, I think, maybe the two stupidest things ever out of the mouth of a Supreme Court member. The first, actually, pre-Supreme Court, was in his confirmation hearing when he said that a Supreme Court justice is like an umpire, a referee. All he does is call balls and strikes. Now, one of the absurdities that hasn't gotten mentioned much is that an umpire and referee does not decide who wins the game. You know, they call foul, force rules, but very often the team with the more fouls will nevertheless win the game. A justice or judge is deciding a case. That's very different from just calling balls and strikes. So that was bad. But worst is his dissent in the Obergefell case, the same-sex marriage case, where he said that that society from immemorially has regarded marriage as limited to male and female, and that includes the Kalahari Bushmen, the Han Chinese, the Aztecs, and the Carthaginians. And who do we think we are? That's the end of the quotation. Now, that is ridiculous. I mean, that is ridiculous. So you start with the Kalahari Bushmen. Kalahari Bushmen are almost extinct. So it's hard. So if you read up about the Kalahari Busmen's sexual and marital practices, you read that, well, they don't really know much about it. They're very informal. Very informal. And but on the other hand, there's actually evidence that these Africa and the southern part of Africa, they have a history of, homosexual activities and so on. So that doesn't do it. The Han Chinese, Han is just the name of the major ethnic group in China. 90% of Chinese are Han. And it's true, China forbids same-sex marriage. On the other hand, if you go back in history, China, you find all sorts of polygamy and homosexuality and all sorts of bad things. And then the Aztecs, I looked at two websites on Aztec marital and sexual practices. One said, the Aztecs, they were fierce. They exercised sodomites. And the next website said, the Aztecs, when Cortez's army arrived in Mexico in the 16th century, they were shocked by all this sodomy that they were observing. So that was the tie. And finally, the Carthaginians. So Carthage was destroyed by Rome. And Carthage was destroyed by Rome in 146 BC. So very little is known about their marital practices. But recently, an Italian professor wrote that now where he got it is obscure. Carthage, he said, was a paradise for homosexuals. And their homosexuals infected the Romans. And the reason the Roman Empire fell was that the Romans had become converted, not all of them, but too many of them had become homosexuals as a result of associating with Carthaginians. Can you imagine anybody putting listing these four civilizations as evidence that same-sex marriage should be forbidden? He's also, by the way, while I'm beating up on Roberts, terrible manager. You look at the Supreme Court, they are still unable, it takes them 5 years to publish their opinions in the U.S. reports. It's extraordinary. that gives them a chance to tinker with the opinions for 5 years before they become, absolutely final. And he closed the front door of the Supreme Court, which the other justices apparently were very offended by because they thought it was a group decision, not for the Chief Justice. And he, like his predecessors, he's the ex officio head of the Federal Judicial Center, which is supposed to be some sort of intellectual arm of the judiciary and educate the judges and so on. And they have appointed, and this has been for a long time, but he certainly hasn't improved it, the people they appoint to the Federal Judicial Center are district judges, magistrate judges, bankruptcy judges, not academics, not who could actually design educational programs for new judges. Also, look back when I was a law clerk in 1962. Well, actually, a few years later, took a few years, but in the late 60s, the Supreme Court was hearing twice as many cases as it hears today. Even though it had only 2 law clerks, I had no electronic research, obviously, and despite the fact that the Supreme Court hears so many fewer cases today, it's allowing less time for oral arguments. And the Supreme Court justices nowadays babble incessantly during oral arguments. They ask a few questions back in the 60s. So you'd think the court having fewer cases would enlarge the time so that the lawyers would get to say something.
So let me ask you, because I'm running out of time. What do you think about Justice Scalia as a justice and in terms of free speech issues?
Oh, I think bad. So the free speech decision of his that sticks in my mind is the burning of the American flag, which he was very proud of as showing that he was, he just decides what the law is, just is guided by the law. It's very silly because he styled himself an originalist. He pretended that he was interpreting the Constitution, Bill of Rights, 1791. But there is no evidence, no reason to think that 18th century people would have thought that burning a flag was a form of free speech. Now, we can say it if we think it, but it's obviously a modern decision. It's not. It owes nothing really to the Constitution.
Can Citizens United be defended from an originalist perspective?
Nothing can be defended. What can be defended from an originalist perspective? I mean, a good example of that, what absurdity it is the Supreme Court keeps saying things like the Fourth Amendment requires that the search of a person's house or arrest in his house requires a warrant. Well, if you look at the Fourth Amendment never requires a warrant. The Fourth Amendment forbids general warrants and warrants that lack probable cause or don't have oath or affirmation in them. So there's nothing positive about warrants in the Fourth Amendment. The Supreme Court wants to say we love warrants. We can't have a reasonable search without a warrant. They could say that. Wouldn't be very persuasive, but they could say it. But it can't be attributed to the Fourth. Another Scalia example is the Second Amendment, the Heller case, the gun case. If you read the Second Amendment and you know anything about the 18th century, it's perfectly obvious that what is going on, the states were very concerned that the new federal government was going to take away the state militias. and have a big standing army like Britain. That'd be terrible. So the Second Amendment, which starts off with a little introduction about the importance of militias, goes on to, and then goes on to talk about a right to bear arms. In the 18th century, with the militias, they didn't have depots, they didn't have arms depots. So they required, not only required that every able-bodied man be a member of the militia, but he had to have a gun in his house. So when, there was fighting, he grabbed his gun, because as I said, they didn't have these muskets and rifles and depots. So the Second Amendment has absolutely nothing to do with personal self-defense. So to defend that on the ground that, and his opinion, full of historical rubbish, 17th century English, people running around with swords. And Stevens made a very serious tactical error in his dissent, because instead of saying, this is all nonsense, just read the Second Amendment, think about the 18th century, nothing to do with personal self-defense, instead, he competes with Scalia on Scalia's own turf and looks at all this 18th century, 17th century history of, England fighting. So then anyone reading the opinions would say, well, they disagreed, and, well, read Scalia's opinion, seems very learned, and maybe Stevens is right, but who knows? So, so we'll accept Scalia's. And on a practical level, what's wrong with Heller is that there's such enormous variance in the United States about guns. It's one thing, if you're off in Arizona or even in southern Illinois, there aren't many people around, there aren't many police. You could see how people would want to have a gun for self-defense. But if you go into the cities, into the slums and so on, it's extremely dangerous to allow people to have guns. So until Heller, the matter of gun regulation was left to the different states and cities and so on, and seemed to work fine. So I think it was a terrible opinion.
Do you want to over that?
All right. Well, thank you. I think we've done the First Amendment, Second Amendment, Fourth Amendment. Do you have any views on the Fifth Amendment? So we're in New York. Please, just to make it a little more collegial, when you ask your question or comment, you might just tell us your name, so Jeff and Dick know. If I can take the prerogative of asking the first question. Justice Holmes, I'm paraphrasing, once said, if people want to go to hell in a handbasket, it's my job to help them. Could that be a Posner maxim?
No. Holmes made comments like that occasionally. The notion was, so he worried about the courts being too prone to interfere with, democratic process with legislatures. So what he was saying in that phrase was, the fact that I think a law is bad is not an adequate reason to vote to invalidate it. Of course, he did vote to invalidate laws, but so he did have that democratic streak in him. On the other hand, there are cases in which very strong personal feelings of his shine through. So, for example, Buck versus Bell, about the compulsory sterilization of a woman believed to be feeble-minded, apparently all erroneous, but he didn't know that. But he wrote the opinion upholding this state practice with obvious relish. And we know from his correspondence and so on that he was a big enthusiast for the genetic movement. It was very big in the 20s and 30s. Big in America because it was felt that the immigrants were lowering the IQ of the American people. I mean, the problem was the immigrants came in not speaking the language, not having good English or no English, and then they're given IQ tests. They do very poorly. So the notion was, the immigrants were dragging down the American IQ, and Planned Parenthood started off in order to try to raise the intellectual level of the population. So homes, like a great many Americans, bought into that. That overrode his, the kind of phrase that Ron quoted.
New York, Washington, D.C., questions, comments? Come on, you have to exercise your First Amendment right here. So, Joel, will you tell us who you are?
Yes, I'm Joel Gore. I teach at Brooklyn Law School. Judge Posey, you seem to have a pretty jaundiced view of most of the Supreme Court's free speech work, and I'm wondering, are there any cases where the court has protected free speech that you think they got it right?
Well, that's a good question. Well, there are was it the Whitney case?
Whitney v. California?
Yeah. How did that?
That was, they,
Went the other, was that a Brandeis dissent?
that was a Brandeis,
Okay.
Well, it was a functional dissent.
it was a concurrence, but it was basically a dissent, right?
So what would be the landmark free speech law of modern times?
New York Times and Sullivan.
Right.
That would be one example.
Right.
There are people who would say the Pentagon Papers case.
But,
Brandenburg versus Ohio.
yes, well, that would be an example. Yes. Yeah, that's right.
Does that speak to your point, Joel?
Well, it's pretty slim pickings, but I guess it does.
So what would you give as examples of cases that you'd be curious to see whether the judge
Well,
agrees with?
that's a whole other discussion. I mean, I think Buckley was correctly decided, and Citizens United followed Buckley, and so that's my take on those issues. But I think Brandenburg, I think Virginia Ward on commercial speech. I think those were important cases. I think Justice Brennan's views on obscenity would have been good for the court to adopt. You can go see whatever kind of movies they want, as long as they're adults. I think Justice Black and Douglas's views on disallowing defamation suits by public officials, absolutely, those would have been pretty good results. So I think there's a lot to pick from in terms of favorable pro-speech decisions or opinions.
But almost every example you gave is a dissent.
Well, Buckley wasn't, Virginia Ward wasn't, Brandenburg wasn't. There are a lot of cases not
Right.
just dissent.
Right. But all the others about Black and Douglas and Brennan, they were all not majority opinions.
Well, no, commercial
That doesn't
speech.
mean that.
Virginia Pharmacy, he said, right.
Yeah.
Do you agree with that?
No.
The commercial speech shouldn't be
I
protected?
don't know why commercials. I don't get it. I don't see, why is commercial speech different from any other commercial activity, right? Doesn't have to anything to do with democracy.
So you would focus First Amendment protection on politically related
Exactly.
speech?
Well, I think not just political, because I think it's important to have freedom of artistic expression, and you know, the obscenity laws can be quite crushing. I mean, you know, like the sort of thing that James Joyce ran into with Ulysses, which couldn't be published in England for, I don't know, 50 years or something. So yeah, that's highly important, I think.
Right. Others?
Judge Posner? Hi, my name's Robin Blumner. And I would like to circle back to the buffer zone decision that you thought was
Yeah.
wrongly decided because it gave anti-abortion protesters access to women who were seeking abortions, basically, with abusive language and pictures. So what if this were instead a labor protest? And these were workers who had been exploited or abused on the job, and they had gone out on strike, and the owner of the company had demanded that they stay 30 feet back so they couldn't get close to the replacement workers who were coming in the door. Do you feel any sympathy for what I consider poor man's free speech? You know, people who don't have the capacity to take an ad out in a newspaper, and all they really have is their physical presence and a placard to express their dissatisfaction.
Oh, no, I think labor picketing is perfectly appropriate exercise of free speech. I do think the factory owners should be able to establish limits that prevent the picketers from actually physically blocking entry into the plant. And but picketing is fine. I happen to be a particular advocate of a form of picketing that maybe you've seen, which is the inflated rubber rat. Have you seen those?
No.
Oh, yeah.
Oh yeah, no, that's
I've never
good.
did.
We just lost one of ours in Chicago. No, what happens is, maybe they don't have them in the East, but
They have them in the
you'll see-
Yeah, they're here.
They do. Okay.
Yeah.
Yeah. So you'll see.
We have them and real ones.
Not quite as
I'm
thick.
familiar with the rubber ones. They're large. They're large rats, rubber rats with a compressor. Keep them up, and they'll usually have the name of the company that they're protesting on the rat's chest, and they're quite common. They certainly are. Now you could say, well, is this commercial? Because they're just arguing over wages, but I don't think so, because there's a labor movement, and the picketers are not just are trying to draw their attention not just to a particular dispute they have with a particular employer, but they're trying to communicate to the community that workers have rights, workers should be able to express themselves. So I don't have any problem with that.
Other questions?
Yeah, this is Lee Levine in DC. Judge, I wanted to ask you a question about another Supreme Court case that you have written about, which is Brandsburg versus Hayes, which is the case in which the Supreme Court upheld the contempt citations against 3 reporters who had declined to identify confidential sources. And in a case you wrote called McKevitt versus Palish, you criticized courts around the country for misreading Brandsburg and recognizing a qualified privilege of at least some sort to give reporters the ability to protect their confidential sources. I was just curious, aside from whether or not other lower courts had been misreading what the Supreme Court said in Brandsburg, if left to your own devices, specifically in the area of confidential sources, which wasn't before your court in the McKevitt case, do you think there is some right in the First Amendment for journalists to protect confidential sources?
Well, I would think it would depend on what the need was for identifying those sources. I mean, what if their confidential source is a serial killer, and the reporter is writing an interesting article about a serial killer, but he doesn't want to identify the serial killer? Don't you think that would be a case where First Amendment should not be thought to protect the confidential source?
I don't want to put words in your mouth, but it sounds to me like what you're saying is that there's a balancing test of some sort
Right,
between the First Amendment interest on one side and the competing interest on the other. Is that
right.
fair?
Yes, that's exactly what I think, yeah.
And so just to follow up on that, Judge, this is Dave Schultz in New York, but wouldn't Judge Sachs' position be right, that if there's a balancing test, there must be some privilege, otherwise there would be nothing to balance? So if a judge is to say anything about it, there must be something for the judge to judge. It's not just the prosecutor's decision.
Yeah, I agree with that, yeah. No problem.
Right, so basically, Brandsburg is wrong, in your view, and there should be privilege, but it's a balancing privilege.
Right, that would be my view, yeah.
Could I ask about a different area? You wrote a decision many years ago, I think it was Alfred Knopf versus somebody, but it basically was rejecting a privacy claim based on historic facts that were socially important. So what would your view be about this whole right to be forgotten movement and how that fits into protection of free speech?
Well, the case of mine that I remember was it was a black couple. I think they'd come to Chicago from the South, and, you know, they had a difficult life, unfortunate life, and they felt their privacy had been invaded by a reporter. And it's not as if their life was something of great public significance. It was not a happy life, and it was embarrassing for them to be exposed, and so we thought they ought to be protected. They were entitled to be protected from that kind of reportorial snooping and revelation. Do you disagree?
Well, my recollection, I thought in that case you came out of the view that there was a legitimate news interest that was protected for the use of that in the book.
Well, we may be thinking about a different case. The one I remember, the one seems to me a good case for a right of privacy. I think it was called something like Hayes, but it's many years ago. There are certainly cases in which the interest in information outweighs a privacy interest. I don't think, I'm actually not much I'm not very enthusiastic about rules. And I like to think about cases one by one and, find a solution that's good for that case without worrying much about the next case.
Judge, this is Steve Wormiel in Washington. Do you think the press clause was meant to have independent meaning from the speech clause? And if so, what should it be?
Oh, in the First Amendment? Oh, should there be a different standard for speaking and writing? I don't know. I've never thought about that. What do you think?
Well, it doesn't seem to have an independent meaning. It's hard to understand why it's there if it doesn't have some independent value.
Oh, you may be giving them too much credit. I mean, they were obviously aware of the fact that a great deal of political speech and so on was printed. People like Tom Paine. On the other hand, there was the Hyde Park corner in London where people gave political speeches. So you can see how they would want to make sure that they were not simply granting a right to talk and reserving a right to censor all published material. That would be an enormous curtailment of what we think of as free expression. So it was sensible for them to add that. Well, there was a long history of censorship in England, so you know, the colonists wanted to get away from that. So.
More comments, questions? We're not, yes?
Hi, it's Dean Regale in New York. Judge, in the discussion you had there earlier, there was a lot of discussion in the Pentagon Papers case, a little disparaging, if you will, how much national security was actually at issue. That came up a little bit in the Snowden conversation. I'm interested in what your sense is of whose role it is finally to decide whether national security is sufficiently implicated in a case to affect First Amendment interests one way or the other. Is it an executive role with some minor judicial check? Is it a judicial determination? How would you deal with that?
Well, the initial decision, of course, is made by the executive branch, or it could be by Congress. But it certainly should be open to people to challenge secrecy rules in government. I do think when they concern national security, the court should be very hesitant to intervene. Not only, it's not so much that they don't know much about national security, it's more that it's very upsetting to people to feel that national security is being treated in a casual way, and courts are saying, well, we don't think the formula for the atomic bomb is that big a deal, because lots of countries have atomic bombs now. Well, actually not a lot, but several. So we think anybody should be able to publish the design of the bomb.
Want to leave it there?
I
want to ask you, if I may.
Follow-up. Can I just
why-
do a follow-up issue?
Sure, go ahead.
The issue of national security and who gets to decide, would your view change if a government claimed that court records contain classified information? In other words, does the role of the court change when someone is seeking access to a court record that the president doesn't want the public to see, or is it the same?
Well, court records, other than those that are, you know, actually placed in evidence in a trial, are, you know, usually, well, it's very strange. The Supreme Court treats all the notes and rough drafts and everything of individual justices as their personal property. It seems absurd, government property. And they let people do things like Justice White said his papers couldn't be examined for 50 years after he retired or died or whatever. So, so the actual status of these court records is really undecided. I think they ought to be regarded as government documents, and whether they should be, I don't think they should be concealed unless there is something about them that should not be exposed. Could be private communications, I don't know.
Can I ask you a question about free speech on campus issues, which are hot questions these days? So the University of Mississippi has a statue of James Meredith, and a student puts a noose around his neck and is expelled for that. Is that, do you think, a violation of the First Amendment?
Oh, I don't think students have First Amendment rights.
Period.
Yeah. Go to school, You're not a free person. No, I don't see why do you want kids to have free speech,
Even college students we're talking about.
especially college
Judge, did I just?
students? No, I'm disturbed by the, this is the 60s. Well, probably too young for that, but this is the 60s again. There's crazy kids running wild. Harvard Law School. Harvard Law School. They start out with this stuff, effacing history. I mean, this is as anti-intellectual as you can get. Just erase history. So some fellow named Isaac Royal in the 18th century, an Englishman living in an English colony, Massachusetts, had slaves. He had 6 slaves, and he was a loyalist. So when the revolution broke out, he said, I'm a loyalist. I'm for England. So the new American government said, okay, you like England? Back to England. So he was exiled to England. But he gave a lot of money. I think it may have been even after he was sent back to England, he gave a lot of money to Harvard, which became the nucleus financing for a Harvard Law School. And much later, there was some, I don't know, there's a royal professorship, and then there was some design or something, a royal design, anyway. And now the students have gotten hold of it and got terribly furious at the thought that there was any identification, particularly the royal professorship, with this slaveholder. And the law school did something. They didn't fully purge royal, but I think they took away the design or whatever it was. That seems to me absurd, right? In the 18th century, slavery was legal in the entire world. So Royal wasn't doing anything wrong by the mores and laws of the time. So to start blaming, people hundreds, thousands of years ago for not having our 2000 AD values, that's ridiculous. Then people end up, they won't know any history. There won't be a Washington monument, he had slaves. There won't be a Jefferson memorial, he had slaves. There won't be Washington, D.C., because that's named after George Washington, he had slaves, right? So you rewrite history and you make the new generation even more ignorant than the last generation.
We have time for 1 or 2 more questions or comments. Bob Cornrevere.
Yes, Judge Posner, do you think the First Amendment permits the government to prohibit hate speech? And if so, how can that be intelligibly defined in a country where some people believe there's a war on Christmas?
I'm sorry, what speech?
Hate speech.
Hate
speech.
Yeah, well, the term hate speech is a little vague because you don't want to sweep up all criticism and call it hate speech because some people find it hateful. No, I think people have to learn to tolerate criticisms of their anything, but again, you have to use judgment. If you're dealing with kids, students, so on, that calls for different rules than for adults. You wouldn't want to have laws that forbade criticism of religion. On the other hand, you might require some degree of civility criticizing things that are important, people are sensitive about.
How about a law prohibiting anyone to display the Confederate flag?
Oh, that's fine with me.
That law is okay with you?
Yeah, in fact, it goes back to what I said earlier about how governments behave in time of war. So, Andrew Johnson, of course he was Southern, who succeeded Lincoln, he made a terrible mistake because when the Civil War was over, the Union should have executed Jefferson Davis, the President of the Confederacy, Robert E. Lee, the other generals, Beauregard, Forrest. And that would have signaled to these people the way what we did in Germany and Japan at the end of World War II made clear to these people that their way of life, their government, their values were finished. And it worked very well with Germany and Japan, which were completely turned around by atomic bombs, by massive bombing of Germany, by execution of a number of leaders of these enemy countries. And if we had done that in the Civil War, we wouldn't have had the problems we still have with the South, which still thinks it's a separate country, that its slavocracy deserves commemoration in Confederate flags displayed all over the place. I regard that as totally intolerable and totally the fault of being soft at the end of Civil War. Of course, Lincoln in his second inaugural, with malice towards none and charity for all, that's baloney. We don't have charity for the people who started a war. What is it, 600,000 killed in the Civil War? More than in any other American war. And for that you say, oh, well, we're forgiven. Southerners, had your beautiful Confederate flag and won a bunch of battles. And that was a mistake.
How about Skokie?
Pardon?
The Skokie case came out of the Seventh Circuit, rightly decided?
You mean marching, the Nazi march?
Mm-hmm.
Oh, I don't see. We have Nazis occasionally in Indiana, march around. No one pays any attention to. They have to be protected by the police.
But they lost the war.
Pardon?
The Nazis lost the war.
The German Nazis?
Yes.
Not our Nazis.
Well, they're fellow travelers. They're like the people in Dennis, the New Ages.
Well, let me put it this way: if Nazism in America became dangerous, sure, it would be appropriate to clamp down on it. But the Nazi movement in the United States has been extremely modest, and I don't feel the same way about the Ku Klux Klan, because that's a large movement and with a history of violence in the United States, whereas I'm not really aware of American Nazis engaged in violent acts. They march around, they have pamphlets, but I think they're basically harmless. Say, if they became dangerous, if they grew, yeah.
You went blank in, is that, life is still good, I guess. We're getting ready to close. Leek, do we have time for one last comment or question, or?
If anybody has one, sure.
This is your final opportunity. Anybody? Okay. Well, with that, I wanted to thank Jeff. Thanks for drawing Richard out, and having him share his views about life, law, and other things that matter. And thanks as well to you, Richard, for giving us
I enjoyed it.
giving us your views, your provocative views on the First Amendment, and that's exactly what it's all about. And just so we have it, I counted 5.5 decisions that you took exception with. There was the McCloskey versus McCullen, Buckley versus Vallejo, the Virginia Pharmacy, Citizens United, Tinker, and half of the Pentagon Papers case. So it is precisely the whole point of the First Amendment to have such provocateurs open our minds and what have you. So please join with me in thanking Jeff and Richard for this. All right. New York, Washington, good night.
Thank
Thank
you.
you.
Thank you.